Okay, so let me welcome you to the Center of Business Law event. Professor Juliet Kostritsky and myself would like to thank you for attending. Today we have Michael Dorf, who is the Executive Director of the Lowell Milken Institute for Business Law and Policy and a professor of practice at the University of California, Los Angeles School of Law. Professor Dorf teaches and researches in the areas of corporate law and entrepreneurship with a focus on social enterprise. Professor Dorf is the author of 2 books, Indispensable and Other Myths, Why the CEO Pay Experiment Failed and How to Fix It, and Becoming a Public Benefit Corporation, Express Your Values, Energize Stakeholders, Make the World a Better Place. His work has been published by numerous law reviews, such as the Southern California Law Review and the Harvard Business Law Review, as well as popular publications such as The Atlantic, the Los Angeles Times, and Politico. He's been quoted or his work discussed in publications such as The Economist, Fast Company, Fortune, the Houston Chronicle, the Huffington Post, the Los Angeles Times, Reuters, Slate, the New Yorker, the Wall Street Journal, and Wired, as well as Marketplace and NBC. Excited to hear him speak today. I've known him for about 12 years. With a lot of academics, they tend to be flashes in the pan. The thing that I've noted over the time that I've gotten to know him is that consistently he is a high-powered academic, and I'm excited to hear what he has to say today.
Thank you so much, Eric. That's such a kind and generous introduction, and it's such a pleasure to be here today. Thank you so much for inviting me, and thank you to Case Western for hosting me so warmly. So what we're going to do today is talk a little bit about what this new entity is. It's relatively new. It came in 2010, so in the history of sort of corporate governance, this is a new thing. This is maybe a flash in the pan, as Eric was saying. It may be something that turns out to be important. We don't know yet. And whether it's something that enthusiasts of this new form think it's going to totally radically transform the economy. Skeptics, and I think there are a lot more of those, think it's just going to be something that's deceptive, or at worst, or at best, useless. And I'm going to take a tack that is, as is usually my want, somewhere in between, which I think is usually where the truth tends to lie. And then also, I think, give you enough of a basis in what this stuff is to make your own decision as to whether you think these are going to be actually very useful or not at all useful. So we'll just do, just to give you a quick outline, we're going to talk about what a corporation's purpose is for traditional corporations. I'll give you a very brief corporate governance refresher, just in case you didn't just take corporations or teach corporations and don't remember how this works. I'll talk about what a public benefit corporation is, why it's different and how it's different from a traditional corporation. Why anyone would ever invest in one. So this is one of the questions that critics raise, is why in the world would investors come? And if investors don't come, the movement's not going to succeed. Why do we think that they're going to behave differently from traditional corporations? That's the other major critique, is they may just look just like traditional corporations, only fool people into thinking that they will be different. And then very briefly, some thoughts for the future. So I'll go probably about, I'm going to try to watch the clock, go about 45 minutes and leave us some time for questions. Okay, so what is a corporation's purpose under traditional law? This is now, we're talking about management theory here rather than legal theory. But under management theory, for quite a while, the answer has been Milton Friedman's answer. So Milton Friedman wrote a piece in the New York Times, I think it was the New York Times Magazine actually, in 1970, in which he said, pushing back against what was already a beginning kind of ESG type movement, a pro-social, think about all the stakeholders kind of a movement among managers of companies, saying, well, the social responsibility of business is to increase its profits, as opposed to all the other litany of things that people were saying business should be responsible for. Friedman said, no, it's just about the money. We're just supposed to make money. But he's not the only, well, he's an economist, he's not the only prominent sort of managerial theorist. And on the other side, in opposition to him, was Peter Drucker, also a very, very famous, well, he really is a managerial theorist, Friedman is an economist, but not really a managerial theorist. But Drucker actually believed in a stakeholder theory. So he said economic performance is certainly important. It's the first responsibility of a business, but it's not the only responsibility. Every organization must assume full responsibility for its impact on employees, the environment, customers, and whomever and whatever it touches. So these kind of other constituencies, other corporate constituencies, including that list and others, Drucker said, no, businesses are also responsible for that. Now, neither of these people are talking about the law. They're talking about the oughts, right? What ought a manager to do as a matter of good, solid business managerial practice? And they have very different views on what they should do. So what about modern theorists? What do modern managers say about this? Well, at least, I don't know how much of this is real and how much of this is lip service, but we got a statement by a whole bunch of them, the Business Roundtable group. It's a group of CEOs of major corporations. And they put out a statement every year, and for many, many years, they echoed Friedman. And a few years ago, they changed the language to much publicity. And they said, we share a fundamental commitment to all of our stakeholders. And there's a lot of language in between, but that includes customers, employees, suppliers, communities, and then shareholders listed last, right? The money listed last. So that sounds very much like Peter Drucker, not at all like Milton Friedman. So they have this shift. There have been a number of people who have looked at what those companies have done with that statement, and it doesn't seem like they've made very many actual substantive changes, but at least they're paying lip service to this idea of a sort of Drucker-like stakeholder theory for management. Now, before I can tell you what the law is on this, I have to tell you how corporate law is made. And for our purposes, for governance purposes, for the most part, I say this with a lot of asterisks and hedges, but for our purposes today, for the most part, it's state law. So when we talk about what we call the internal affairs of a corporation, that is disputes between or among officers, shareholders, and directors, those are the three big players in a how a corporation is run, those disputes are governed usually by state law for most issues. Which state? Well, the board of directors is in charge of most decisions at a corporation. And so there are some issues where the shareholders also get a vote, and they certainly delegate a lot of decisions to management, but that still remains within their authority. So it's not terribly surprising that the board gets to choose which state, and they do that by choosing which state they incorporate in. So every corporation has to be incorporated in one state. They also have to be licensed to do business in what they call foreign jurisdictions, but they don't govern, that doesn't choose the law. What chooses the law for internal affairs is the law of the state of incorporation. And states compete for those incorporations because they come along with franchise fees, a special tax, it's a great tax for states because it's like a hotel tax. You don't have to provide very many services, but you get all the money. You have probably some services, but not very many. Like leave your court system open, have a reasonable system of law, but that's it. So it's a great tax, and if you're a small state in particular, you can make a substantial percentage of your tax revenue from the franchise tax. Now there's a debate over whether that race has resulted in the best possible law for shareholders, which would be like a race to the top, or the worst possible law for shareholders, a race to the bottom, or some kind of race to the middle because of federal competition or the threat of federal competition. But we know who won the race, whether it's the top, the bottom. We don't know where the end goal is, but we know who won, and the answer is Delaware. Delaware is clearly the winner. Whatever that means, they won. By which I mean this. So for large companies, for publicly traded companies, we're getting close to 2/3. It's north of 60% now of publicly traded corporations. I think it's like we're almost at 65. Is that right? Eric will correct me if, say about 65%. And last year, I think it was like 85 or 90% of new IPOs were registered, new initial public offerings, companies that newly went public, were registered in Delaware. For smaller corporations also, they punch way above their weight. And the typical thing is a corporation will either register in the state where they have their headquarters, or they will register in Delaware. There are a few states that have tried to make a play. Actually, there's been a lot of scholarship about this lately, including my colleague Steve Bainbridge has written about this recently. But Steve actually gathered some data on this, and Nevada has a few, Texas has a few, but for the most part, really Delaware remains, despite a lot of talk, and you hear about Elon Musk saying, oh, we're all leaving. His companies were really the only really big companies that are doing that, other than REITs. There's a special thing about REITs, real estate investment trusts. So Delaware is the winner. So what that means is what we care most about, what we care most about is Delaware law. You didn't miss anything you don't already know, so you're okay. What we care most about is Delaware law. And that's true, I think, of PBC, in this space also. That is, Delaware calls their entities, these pro-social entities, public benefit corporations. That's a different name than most states. Most states call them benefit corporations. I'm pretty sure Ohio calls them benefit corporations. But we care most about that because the large companies and the venture-backed companies are most likely going to be public benefit corporations. In fact, I'm stepping on my own story a little bit, but all of the publicly traded entities that are like this, that are pro-social, are public benefit corporations. They're registered in Delaware. So what purpose does Delaware say? So we heard Milton Friedman has one idea from a managerial perspective. Oh, it should be for making money for shareholders. We heard Peter Drucker, again, trying to train managers. He says, no. Money for shareholders is important, but we also have to think about other stakeholders. What does Delaware law say? Delaware law, pretty clearly, there's some controversy about this, but pretty clearly they adopt the Friedman approach. Okay, maximize shareholder value. There is, to my knowledge, exactly one modern case which squarely confronts this. There's some discussion, there's language, there's what we call dicta in other case opinions. There's a Michigan, this is next door to you kind of, or at least nearby Michigan. There's a very old Michigan case about Dodge and Ford, Henry Ford and the Dodge brothers that has a lot of language about this. It's not actually determinative in the outcome of that case. And that's an old case. This is the only kind of modern case that squarely deals with it. There's some M&A cases in Delaware that have language about it, but this is the only case it's a weird set of facts that squarely deals with this issue. And it says, absolutely, we agree. It didn't mention Milton Friedman, but we agree with Milton Friedman. They say it's a case that dealt with Craigslist. You may know Craigslist. Having chosen a for-profit corporate form, the Craigslist directors are bound to promote the value of the corporation for the benefit of its stockholders. The Inc. after the company name has to mean at least that. Okay, so. And also Leo Strine, the former Chief Justice of the Delaware Supreme Court, he wrote a law review article about this, and he said he doesn't like the answer, but he says this is the answer. Okay, if you talk to him, you know he doesn't really like the answer, but this is the answer. So if that's true, we have a really important problem to solve as a society, which is we have built into the DNA of these very wealthy, very powerful organizations a desire to make money, period. That's their only job. That seems like a recipe for disaster, right? Like, what prevents corporate bad acts? What's going to prevent them from doing terrible things in order to make money? And the traditional answer is government regulation. That is outside, it's external government regulation, outside of corporate governance. So we're sort of building a dichotomy here. We have the internal regulation of the entity that decides how disputes are managed between shareholders, officers, and directors. That's governance law. And then we have external regulation that applies to all legal people, whether those legal people are flesh and blood human beings or cold, lifeless corporations. It still applies to them. So think about things like environmental law, employment law, various product quality laws, whether that has to do with like Food and Drug Administration or the safety of airplanes. All of that stuff is external regulation, and that's what's supposed to regulate corporations. And so it's sort of we add an asterisk to the stock maximization, shareholder price maximization theory, where we say, yeah, you have to maximize return for shareholders within the bounds of the law. Within the bounds of the law. All right, that sounds comforting. After all, none of us speed, right? So it's the right answer. There are some problems with the traditional approach. One of them is regulatory capture. So I like this cartoon. I found this cartoon just the other day. I really like it. Especially since 2010 with Citizens United decision, but let's be honest, forever, since there have been modern corporations since the 1880s, there has been a problem with corporations choosing to shape the rules that govern them, whether those are environmental laws or the railroads or the banks. They have always lobbied the government in its various branches. That includes administrative agencies, Congress, maybe not so much judges, but certainly the presidency, where they have tried to shape the rules that govern what they're allowed to do. And they're very powerful and they're very wealthy, and they're even more enabled to do that since 2010. And so that's a serious problem. If they're able to write the rules that govern them, then we're back in the original, or almost back in the original problem, which is they're just going to run roughshod over the society. A second problem is inadequate enforcement. So even if we thought the rules were the right set of rules, are they being adequately enforced? And there are some reasons to think they're not. One is that even though the government spends trillions of dollars more than it earns every year, I don't know why nobody talks enough about that. Where's Ross Perot when we need him? It spends lots and lots of money, so it seems odd to say, oh, they don't have enough resources, but they actually don't when compared to these issues that corporations care a lot about and can bring all of their resources to bear. And they also are usually not as sophisticated as the private entities that they are regulating. That's particularly true for things like complicated Wall Street products, things from coming out of Silicon Valley, where the government is, the people who are best at this are making money at it. The people the government can afford to hire are usually not at the same level, and so they don't have the sophistication or the resources really to go after. If you want to get some intuition, think about the IRS. They often don't go after the biggest abusers of the tax code because the biggest abusers have lots of money to defend themselves, and the form of their abuse is complicated and hard to explain to a jury. That's also true for like white-collar criminal defendants. They're often very hard to prosecute because the crime is hard to explain to a jury. And so a natural response on the part of a prosecutor who is judged by their success rate in getting prosecutions is to stay away from those cases. So inadequate resources, inadequate sophistication, and maybe some jury issues too. And then even if we prosecute them and convict them, the penalties are usually not that large. They're large to me. I was going to say to you and me, but I have no idea how much money. Maybe you guys are all really wealthy. But to me, these penalties often sound very large. But Eric, you have to afford all those suits. I don't know how you know. So you don't get caught. That's good. You're smarter because you're smarter than the government. The penalties as a percentage of the revenue or market capitalization of these companies is generally pretty small. So it's a slap on the wrist that they're often just sort of willing to absorb as a cost of doing business and then continue to do business the same way. So this is, this is very negative on corporations. By the way, I should say, I love corporations. I spent my whole adult life studying them, thinking about them. It's not because I hate this, because I love them. But sometimes we have to recognize that even people we love have flaws. So, this sounds all very negative. I absolutely credit corporations for almost everything good we have. So I'm very grateful to corporations. But also, we have to recognize they get blamed for a lot of bad things, like global warming and income inequality and employee misery and sometimes fraud. So not just because corporations function well as a whole doesn't mean they function well all the time. And that's true of human beings too. We can think human beings are great most of the time, but sometimes we do terrible things. And corporations, that's true of also. So is there an alternative approach to this one, which maybe is not functioning? It's functioning pretty well. Let's acknowledge it's functioning pretty well, right? We have an economy that is growing tremendously, especially if you compare it to Europe. So 20, 30 years ago, our economy and Europe, the EU zone, about the same size. Now we're almost double, almost double. So the American model, not so bad, right? It's, if what you want is more goods and services, we gotcha. Now, if you like equal distribution of goods and services, we're not so good. If you're worried about global warming, so-so. But from a pure production perspective, enormously successful. So we should, I don't want it to be too negative. I want to make sure we're in between. So the alternative approach, the benefit corporation. Okay, so what is a benefit corporation? And now I'm going to stop saying benefit corporation and only say, I'll probably say PBC, for public benefit corporation, because we're dealing with Delaware. You'll see this quoted statute a few times, because this is the heart of it. There's a lot of nuance, but this is the heart of it. The difference between a public benefit corporation and a traditional corporation is this. A traditional corporation, we said, the goal is maximize shareholder profits. For a public benefit corporation, the duty of the board, what we call a fiduciary duty of the board, is more complicated than that. Instead of just trying to maximize shareholder profits, which is hard to begin with, it's hard to figure out how to, if it was easy to make money, we would all do it. Like, it's hard to make money. Now they have to look at, in a PBC, they have to look at making money and balance that against the best interests of all of those materially impacted by the corporation's behavior, by its activities. That's incredibly broad, at least in potential. It could mean, it almost certainly does mean the company's employees, its customers, its communities in which it functions. It probably means its suppliers. It might mean its suppliers' employees and its suppliers' communities and customers. It probably also means the broader physical environment, since that's something that is a way of impacting all those who live in it, which is all of us. And in addition to all of those who are impacted, they have to pick, in Delaware, some specific public benefit that they are going to pursue. Now, that definition of what can they choose? They can choose almost anything. So, for example, technology is something they can choose. So Microsoft could say, well, we're pursuing technology, so we're now a public benefit corporation. They could. Don't get too cynical about that, though, because 501c3 is pretty much just as broad. That's the federal tax statute that governs charities where you can donate money and deduct your donation. Also really broad, okay, really, really broad. So that's how we make it apolitical, is we keep the definition broad, but when it's apolitical and broad, it also lacks a certain degree of substance. It's not a good brand. Okay. So that's the basic idea. We're going to balance profit against other interests instead of just pursuing profit. So we're going to try to incorporate into the very DNA of the business a desire to think about broader social goals than just making money. Making money is a really important social goal. That's how we get lots of goods and services. But it's not the only important social goal. There are other important social goals too. That's radical. So a little history, because we can't, I got to be a scholar. So a little history. Again, PBC is Delaware's version. Benefit corporations were first invented by, this is a little bit of a lie, but I tell the whole story in the book, so read the book if you want to hear the whole story. But it's mostly true that B-Lab certainly rode the laboring oar. There were some people before them, and then there was a little bit of a fight, but they're all friendly now. So B-Lab, what they do is they certify companies as being pro-social. So there's a 200-question self-assessment that companies can take, and it's score from 80 to 200. And if you get above an 80 and you pay a fee, you can use that logo on your branding, and you can tell everybody you're good for the world, right? So it's like organic or fair trade coffee or something like that. Like, it's certifying, oh, we're good. But they had that for a while, and they felt like it wasn't enough. They wanted some sort of legal stickiness to this kind of status. And so they invented this idea of a benefit corporation. A bunch of lawyers volunteered and helped them write the statute, and they ran around trying to persuade somebody to pass it. All right, so I said that already. And then the first state, anybody guess or anybody know? First state to pass benefit corporation legislation? It's not who you would think. Well, you probably know. Yeah, all right, so what you can say it if you want. So it's Maryland in 2010. Corporate law professors should not be allowed in to answer my questions. It's Maryland in 2010. California was close. But there, well, anyway, that's a whole other story. You don't have to hear that story. Delaware was very resistant, but they did eventually come around, and they didn't want to do the model act that B-Lab was sort of selling to everybody else. They said, oh, we got to do it ourselves. We have to do our own way. They went through this whole process, and they passed their version in 2013. There are some minor differences. Most of them are differences in sort of nomenclature or emphasis rather than substance. And if we could talk about that, but Leo Strine agrees with me, so I know I'm right. Leo Strine is a former Chief Justice of the Delaware Supreme Court, so he told me I'm right, so I'm right. So again, the core difference, remember, is this balancing requirement. That's the idea. How popular are these? Well, by one measure, they're enormously popular. So the blue state, this is not blue, this is blue versus yellow because, you know, UCLA. I mean, it's not blue versus yellow, we're both blue and yellow, or blue and gold, I guess. The yellow states do not have a statute, the blue states do have a statute. So you see, this is not particularly political. Texas has one, but so does California. Florida has one, so does New York, right? So there are still a handful of states that don't have it. Some of them tried to do it and it didn't go through. Some of them just don't seem to care. A lot of these are states that just, you know, don't have very much corporate law. Or, I mean, some of these states that passed it don't have much corporate law. So I'm not really sure why all of them did it, but you know, if it was just a matter of preserving resources, I would have said there are probably 5 or 6 states that need corporate law and the rest of them probably can just defer to Delaware. But, and actually some other countries also. So, well, Puerto Rico is a territory. British Columbia, which is a province in Canada, they have it. The country of Colombia, the UK has it, and Italy has it. Now, these are not exactly the same, right? But this core idea of balancing instead of profit maximizing exists in all of those countries. How many are there in the US? We don't really know. Why don't we know? Because lots of legislatures passed this, and then they said, all right, that's all we have to do. They didn't say to the secretaries of state of all of these states, oh, you can have some more money now to track these and deal with them differently and supervise them to make sure they're doing what they're supposed to do. So for that reason, Delaware is doing a great job. And they're really, really nice to scholars. So when you call them up and ask them for a current list of them, they give them to you. They've done it to me several times. Other things that I've asked for, they have said no to, so they're not always perfect to scholars, but they are at least very nice. California, I have called, I don't know how many times, and asked the question, I don't know how many different ways. They said that it's not possible to tell whether a corporation is traditional corporation, or actually we have 2 versions of it in California, but we can't tell either one of them. One looks like the Delaware statute, one looks like the model statute, but again, they're not really all that different. So we think there are a number of people who have tried to count them in various ways. They're not super accurate, but at least 10,000. I feel comfortable in saying there are at least 10,000. So skeptics, again, there's sort of 2 major skeptical questions, I would say. One is, no one's going to invest in this thing, right? No reasonable investor is going to invest in this, and without money, there can be no business, so this is going to fail. And then the second question, and by the way, there are no tax benefits. That's often what people jump to. I'm just going to tell you up front so we can forestall that question. No tax benefits. If there were, this would be much more popular. Like LLC, limited liability companies, which is the last really major, there have been others, but the last really major successful innovation in corporate governance law, it foundered for years. Anyone know, well, other than Anat and Eric, anyone know the first state to pass an LLC statute? You'll never guess if you don't know. You know? Wyoming, very good, that's right. Wow, well done. Wyoming, like, I don't know why, I don't know the story behind it, but Wyoming was the first one in 1977 or 78. Someone will correct me. It's one of those 2 years. No one cared for quite a while. It wasn't until the IRS came along and issued its check-the-box regulation that indicated there would be tax benefits for these pretty easily available, that everybody, you know, that there were a few states in between, but then lots of states did it, and then they became enormously popular, right? Because there's a tax benefit for them, flow-through taxation. And then again, the second critique, what assures us that PBCs will behave differently? Are these things really going to be different, or are they just going to be kind of fraudulent? Okay, so again, to flesh this out, why would anyone invest? The problem is that PBCs may spend money on their social causes, right? So instead of just focusing on making money, they may focus, at least to some degree, on the mission, or promoting, like paying their workers too much, or making the quality of goods too high. You know, these are real problems. And that will result in a lower return to investors. So as an investor, and I have a choice between two comparable businesses, one's a traditional corporation and one is a PBC, I'm going to choose traditional corporation every time. That's the argument. So to get at this, I think we have to be a little more nuanced, first of all, about who our investors are. And I'm going to say, not a huge amount of nuance, I'm going to say there are two types of investors. The first are traditional investors, wealth maximizing investors. Rick Alexander calls these non-concessionary because they don't concede return for anything. They just want return. And then we have purpose-driven or concessionary investors. There are actually more types of investors than this. Like there's an in-between group that is profit-driven but thinks that investing in social causes is actually profit maximizing. So whatever, but this will do for now. So we have to think about these a little bit differently. So let's think about the harder one first, these profit-seeking, non-concessionary investors. You see the like really multicolored fun money, unlike our boring money. PBCs, first of all, here's an argument. This is going to be a little counterintuitive, so it must be right. PBCs might earn more money than traditional corporations. Let's turn it on its head, right? That's a typical law professor kind of move, okay? So how could that be true? Well, they might garner goodwill from important constituencies who can reward them. So we think about employees. They might work harder, longer for lower wages because they're working for a company they believe in. Customers might pay more for a similar product or be more brand loyal because they believe in the mission. This is especially true of younger generations than mine, according to the survey data. Communities might be more warm and might even give some benefits, tax benefits or something, to companies who come in where they think they're going to behave better. The environment might care. I don't know how they're rewarded there exactly. And this one, honestly, I don't remember what it says. It's too small for me to see. But the point is that, suppliers. Suppliers. I couldn't find a good graphic for suppliers. So suppliers might care, right? So they might give better prices, might be better credit terms, you know, maybe they think you're lower risk. Maybe the environment one's supposed to be investors too, might care. Investors might care. So all of these constituencies might care and might give you a better deal. And therefore, since you're getting a better deal, you might make more money. Okay. Here's another reason you might make more money: purpose washing. Purpose washing is like greenwashing on steroids. The idea here is we're not really better in any meaningful way, but we get all the benefits of appearing to be better and don't have to spend any money on it. That's going to improve our bottom line. So it's like the same argument as before, except we don't actually do anything. So that's one set of reasons. One set of reasons investors, non-concession investors might go for these is because they might actually be more profitable. Maybe they also might be lower risk, right? Because they don't run around violating laws all the time. They don't get sued as much, maybe. Those are also some theories. Again, there's a book. I don't know if I mentioned this. There's a book that Eric mentioned. It's for sale. You can buy it. You can read it. This is a short version. The book is the long, not even that long. It's very readable. You can read it at the beach at the lake. Beautiful fall day. You could take a beautiful fall day, have some cider with a little spike in it. You could read some. It's very nice. Okay, I'm getting excited right now. I want to go outside and read a book. Scarcity. Here's another theory, which is scarcity. There could be a scarcity story here. Of high potential investment. I'm thinking mostly about VC world here, the venture capital world. This might be a good enough corporate form. It's not ideal, but given that there aren't enough really good opportunities for us to invest our money, and there's so much money competing for these relatively scarce good investment opportunities, this team is a little crazy and they're dedicated to their cause and they want this legal form to reflect their belief. And we can live with it. We think they're not gonna be too nuts. It may decrease our profits by 5 or 10%, but overall they're gonna do so well. The difference between getting 10x returns and 8x returns, 8x is still a lot better than we're gonna get elsewhere, so we'll take it. we'll take it. It's not perfect, but it's good enough. And there is some evidence for this theory. So if you look at, I don't have super recent data for this, but look at the late 1990s, it's like the heyday of the VC world when it was really good to be a VC. There wasn't that much competition. About $29 billion a year was being invested by VCs. And their average, this is crazy, I can't believe this was true, but the average annual VC return in the US was 88%. If only we could all have invested back then with VCs. Of course, I could not have afforded, I still can't afford to invest with a VC. They have high minimums. In recent years, it's not so good to be a VC. A lot more money, 2.5 roughly times as much money per year being invested. It varies from year to year. SoftBank really changed this recently. It's much higher now. SoftBank is more than that all by themselves. 15% return. Boy, you see that in SoftBank too. SoftBank is probably negative something. I don't know what they are, but they did not do well. So that sort of suggests the scarcity theory, right? That there's a lot more money chasing the same, the number of really good opportunities has not grown in proportion to the amount of investment dollars chasing those opportunities. And so we see more competition for those, so they're getting better deal terms. And we've got to look harder for it. And maybe one of the ways we give better deal terms is we indulge them in this PBC form. Okay, concessionary investors, that's super easy because we started at what time? 4:30? Oh, I gotta hurry. Okay, concessionary investors, if they believe that PBCs are more pro-social, then they should invest in them, right? So think about like a foundation that has a cause, and they're investing in a corporation that also has that cause, then they're getting sort of double bang for their buck. They're making some money for their endowment, but they're also, it's as though they had given money away to create their cause. So if PBCs really are better for the world, then concessionary investors should like them. And there's a fair amount of money, I will say. It depends on how rigidly you define what a concessionary investor is. The broadest definitions are probably in the low trillions, but that includes things just like that filter out tobacco companies, right? So I don't know how really concessionary they are. That's more like they think this is a way to make money. But certainly in the hundreds of billions and maybe even in the low trillions of money. So it's significant. It's not, it's not everything, but it's significant. We don't really have time to do my. So I did a study a few years ago with Stephen Solomon at Berkeley and James Hicks, who's now at WashU, although he was a student of Stephen's at the time, so he did all the real work. When we say hand-collected sample, that's what graduate students are for, and that's what James did. So we looked at the Delaware PBCs, all of them that existed in 2017 and got VC funding between 2013 and 2018. I'm going to skip ahead to the takeaways because we don't have time for all of this. Will VCs invest? The answer is yes. They were investing in significant numbers, well over $1 billion in total investment during that period. And that even excluded Laureate Education, which by then was our first publicly traded PBC. So we excluded them because they would have swamped all of this. It would have just been, all the results would have just been whatever the answer was for Laureate because they were so much bigger. So we excluded them. And even excluding them, it was a lot of money. The investors were traditional VCs for the most part. It was Andreessen Horowitz and Sequoia Capital and Google Ventures. Those were some of our biggest investors. It was not really, I think of the top 10 investors, I skipped this slide, but of the top 10 investors, only one was a sort of pro-social concessionary investor. 9 of them were just traditional investors. So yeah, like Andreessen Horowitz and Google Ventures. So the one downside we saw was they do seem to be investing less for a given round. It wasn't just that these were earlier stage companies. Like even looked at for a given round, they were in fact investing less, maybe because they felt like these were a little bit riskier. So they were risking less. But it's also true that we only had about 180 of these versus I think 9,600 traditional investment targets. So it could be a small numbers problem. Right? We're not really sure. And they were mostly consumer. The consumer-facing businesses were much more likely to get investment, which actually was what our theory was because we thought, it's because they think customers will like this. So business-to-business businesses, they probably don't care as much. Some of them do, but most of them probably don't. But if you're selling to people, especially to young people, they might care, and so this might be actually a successful business. So it's kind of the first theory of why investors might like this, because it might actually make more money. A few other optimistic signs about this, just very quickly. There are a number, just 4 actually, subsidiaries of publicly traded corporations. So these are really sophisticated investors. Publicly traded companies are very sophisticated. They have themselves invested in companies they own entirely, actually, that are public benefit corporations, or benefit corporations in this case. So the largest one in the world, I believe, is Danone North America. It's a subsidiary of the French company Danone. You might know Danone Yogurt. That's them. They're also certified B. Plum Organics is owned by Campbell Soup. Athleta, owned by The Gap. They're like in most malls now. Ben & Jerry's, 17 of my pounds are because of Ben & Jerry's probably. So they're owned by Unilever. So these are all either PBCs or BCs. Also, we have a bunch of publicly traded corporations like Allbirds, Warby Parker, Lemonade. And there are some well-known businesses that are not publicly traded, but you might have heard of. And in particular, in the last week or so, well, last couple of weeks, we've been talking a lot about OpenAI. Anthropic and xAI are already public benefit corporations. These are competing. I mean, they're much less successful, but they're competing with OpenAI in the artificial intelligence space. And actually, I'm speaking at UCLA, I can't remember exactly when, next week or the week after. There's a panel of us talking about what OpenAI is doing and how they're converting, and I think you guys just did that too, so I want your notes so I can copy them later. Then I'll know what to say. But I have some theories about what to say, but I'll be corrected by you. But there are a lot of other companies as well that you probably have heard of, like Mark Cuban. He started this new pharmacy, basically. Mark Cuban Cost Plus Drugs, they're a PBC. Serena Williams started a company you may not have heard of called Will Perform, but that's a PBC or a BC. Patagonia, which you know, probably 7th generation, right? So there are some big companies that have chosen this form, mostly with a pro-social kind of business model. On the other hand, there's Etsy, which seemed like it was going to be it went public as a traditional corporation. It was certified B, but that meant they had to convert at some point, and then their business model didn't work so well for a while. People were not so crazy about homemade crafts for a while, and that made them nervous that the shareholders wouldn't vote to convert, and the management got fired and changed over, and whatever, it didn't happen. Honest company, never did it, maybe because they weren't so honest, I don't know. They've gotten into some trouble over time. But, all right, so some reasons for happiness and optimism, some reasons for skepticism there. And then in terms of the second skeptical question, I'll have to do this really fast. There are 2 primary statutory protections of the public purpose. One is that duty to balance we've seen a few times. The other are the disclosure obligation. In Delaware, it's every other year to the shareholders. In most states, it's every year to everybody. You have to put it on your website. They've got to do what's called a benefit report. But enforcement of the duty to balance is only by lawsuit by the shareholders, not by beneficiaries. It's got to be a fairly large shareholder. In Delaware, it's 2% or $2 million, whatever is less. There are a lot of procedural requirements, which I won't bore you with. Again, beneficiaries have no standing to sue, so it's got to be the shareholders who seem the least likely people to complain about making too much money and not enough purpose, unless you get a, like a foundation kind of shareholder. And it's a very, very, it's an easy test to meet. It's akin to the business judgment rule and probably will be interpreted the same way. There's a lot of negatives here, but as long as the directors were informed and disinterested, and this is terrible but phrasing, but not such that no person of ordinary sound judgment would approve. In other words, it's a very low bar for the directors to avoid liability. And actually, they're usually protected from liability anyway by a different statute called 102B7, which is, you should take BA if you don't know what that is, but or retake it. Or I'll tell you in Q&A. And again, this is just so it's not likely to be a breach of a higher duty. It's probably a duty of care issue unless there's really bad behavior, purposeful bad behavior. And the disclosure obligations, the problems are it's only to the shareholders, not to the public. Now, if it's publicly traded, then it would be filed with, actually, I said that. I looked at the disclosures for a number of these publicly traded PBCs. Some of them some of them incorporate it by reference, so you can have a link or something so you can see it in the public filings. Some of them kind of copy it in their filings. Some of them do a better job, some of them do a worse job. If you want details, there's a chapter in the book about it. And there's actually, other than Minnesota, I don't know how you feel about Minnesota. Other than Minnesota, there's really no enforcement of this by the states. Minnesota has 100% compliance, because if you don't comply in Minnesota, you lose your BC status. And the Secretary of State actually enforces that. Every other state, I think Harlan Wells did a study, is something between 5 and 15% compliance. So most of these companies are not turning them in. If they're publicly traded, we might see, maybe the SEC will get interested in this. They've been sort of interested lately and in the enforcement division on thinking about ESG claims. So maybe this is sort of a related claim that they'll get interested in. It's probably too niche for them, but we'll see. We could, however, have non-statutory mechanisms like customers who get upset with how the company is doing. They might stop buying from you if you purpose wash. Employees might quit or do soft quitting, or at least stop giving you more work for less money if you don't really fulfill your purpose. Culture, I'm a big believer in the power of corporate culture. That may, in fact, impact how these companies behave. And I don't say this here, but I have a whole chapter on private ordering solutions, where companies could adopt, if they wanted to, ways of making these things more transparent and more enforceable, more measurable and more enforceable. So last slide for the future. If this is going to succeed, I'm not saying it should succeed, but if it's going to succeed, we definitely need more network effects. So we need lawyers to understand this. I talked to a lawyer just the other day who said, what's a PBC? Actually, which is a step up. A few years ago, I was talking to corporate law scholars, even at like Columbia, who didn't know what these were. So we're doing better. I think most of them now know. And more people are writing about them. For a while, it was like me and 2 other people who were writing about them. And now there's actually a lot of people writing about them. People are interested in them, so that's good. We also could, this is a weird thing to say, we need some lawsuits. So far, no reported opinions dealing with fiduciary duties. We almost got one in Virginia. I was super excited. It was actually a company I'd interviewed the CEO and founder a long time ago when I was doing a different project. And it's not just a PBC, but not just a BC, it has a whole other set of nonprofit organizations. It's kind of like OpenAI that way. And they started making too much money. It's like Sam Altman before Sam Altman. Only in this case, the Sam Altman was actually the one trying to pursue the purpose, so I'm not sure that works. But anyway, they settled out of court, unfortunately. So I was very sad. We did not get a reported opinion. And so we're still waiting for that. We may be waiting a long time. But I will say that if people want to know how these things should work, they should just read the book. I explained very clearly how this should work. And hopefully, if we do get a reported opinion, the judges will read the book, and they'll know how to do it, and they'll do it right. If they mess it up, it's not my fault. I did everything humanly possible to make them do it right. So I'll pause there and just say, are there any questions? Thank you. Thank you for your kind attention.
Of all the various things you sort of are measuring or sort of using to gauge the success of the PBCs, one thing I didn't see was was there was any way to track whether they're, because you mentioned one of the concerns is one of the concerns is that investors might have is that there'll be less profits. The profits will be diverted. Has there been any study, or do you foresee any way in which profits can be measured among BCs or PBCs? Have they been more or less profitable than the typical corporation?
So I'll tell you that I will not do that study right now because the answer would be bad. Because the only place we can look at, where we actually get data from is the publicly traded ones. And most of them came out like 2021 to 2023. If you look at not just PBCs, but if you look at IPOs in that period, it's a disaster. right? Very few of them are trading anywhere close to their IPO price. So it's not surprising. In fact, I think I mentioned one of them went bankrupt, and it was one I invested in, so I'm really upset. Don't take investment advice from me. That's another lesson. So I think the numbers are too small of publicly traded companies to really do a good comparison. I mean, you could look at, this is kind of an excuse, but you could look at other IPOs at that time from similar industries and say who suffered more, but it's still kind of a who suffered more story, not who was more successful, which is not very inspiring. But it was just it's a bad period to be investing in IPOs. So over time, now we had a rush of them for a while. I was like, oh my God, I'm getting all these alerts. They're happening all the time. And then they just kind of fizzled, and we haven't had a lot of those lately. No, well, actually, now we're getting all this attention for OpenAI, but, and maybe that will result in more. When we get to the point where we have like 100 of these, we can do a reasonable study of that. Or if VCs are willing to give me their data, if you know any VCs who are willing to give me their data on returns, I would be thrilled to do that. I'll make James do it again. But we would be thrilled to do, the three of us would be thrilled to do that study. I'm sure I'll speak for all three of us. But I don't know, do you know anyone who has that data? Like, do you know any way of getting VC data, like return data?
Return is hard, but I would start with
like
the
individual
NVCA.
investment return data.
I would start with the NVCA because they can send to all their members, and some of them actually collaborate with that. I'll hook you up.
But yeah, but the ones who, it's voluntary, like the ones who respond are going to be the ones who succeed,
Exactly.
right?
Yeah, so you're not going to get.
It's like looking at angel investment returns. Have you guys looked at this data? Like,
Yeah.
ooh, so if there's a survivorship bias, like the ones who are still around, the angel investors, very early stage, the ones who are still around to tell you that they're angels and they're successful because they're still around, right? And they also, it's all like what they remember. They don't have good accounting, so they're like, oh yeah, we're doing great. It's like the people who go to Vegas, they're like, oh, I'm up. No, you're not. I guarantee you, if you've gone for more than an hour, you're not up. I just guarantee that. So if you're a regular visitor to Las Vegas, you are way down. You are way down. All right, anyway, yeah, sorry.
So I'm a huge fan. Thank you so much. I'm definitely getting a copy today. And I have two quick questions. One is, I know Delaware changed the laws with regards to converting to a PBC. Has it been helpful at all? What do you think about that change? Second is, what I struggle with is the fiduciary duty issue. I think that's really the challenge here for lawyers. Before they tell their clients, okay, go ahead and adopt this, we don't have clarity as to the exposure, right? If I'm a corporate counsel, I'll be having nightmares recommending this because I don't know what's going to happen to the board. Yeah. So how do you make them, feel comfortable?
So I'll answer this question, but really this is a good question for Suze McCormick. I don't know if you know Suze, but she's a lawyer at one of the big firms in San Francisco. I can't remember. She's actually was one of the early drafters of some of these statutes and represents most, if not, many of these large corporations. I would say this. First of all, you're right. Companies tend to be nervous, and general counsels tend to be nervous, and rightly so, because we don't really know. But the statutes are written really strongly to protect directors from liability, and they're written to make it. I think quite clearly put this in the business judgment rule bucket. And we know business judgment rule is basically a get out of liability free card. So what I'd be more worried about than the boards is the D&O insurers. They do, Suze has told me there is an issue. It is not easy. I think she spends a lot of time talking to D&O insurers to persuade them that this really is, if anything, less risky. And here's another way it's less risky, is there's something that we call the sweet pill. So in theory, at least, I don't know how true this really is anymore. Anyway, in theory, sometimes when companies are in what we call a Revlon moment, they are required to sell. It's complicated, and it's probably less and less true these days, but at least for a while that was true. A public benefit corporation can say, I don't have to sell because I don't have to maximize profits for shareholders. And so I can choose to sell to one buyer who's giving us a lower price because they're going to pursue my purpose, and not another buyer with a higher price who's not going to pursue my purpose. So there's actually, in that way, they're reducing the chance of liability. And actually, one of the critiques of these has been that it increases agency costs because boards can kind of do what they want and just claim they're pursuing the purpose, and they can't get sued successfully because the obligation is it's permission to balance, right? It's permission. One way of thinking about it is a permission to balance. And I think that's actually a more accurate way of thinking about the liability here, is it's reducing the risk of liability by giving more leeway to the board rather than increasing the chance of liability. So far, I mean, no liability, but no cases, and I think there's a reason why there are no cases. For this is the reason. So I think rationally they shouldn't be nervous. Will they be nervous? Maybe that's part of the problem. And the conversion, I think, definitely helped. I think we saw a slew of conversion, I think 5 or 6 of them had converted. Most of them came to the market this way, but I think 5 or 6 converted. And so Delaware originally, I think it was originally 80% shareholder vote, and then it was 2/3, and then they went back to just a regular absolute majority, which is the rule for any kind of amendment to the charter. And that made it, I think, much, much easier to get, and people are much more willing to try. Yeah. Eric?
So a couple of questions. First off, I think is a variation on a theme that you probably get of, do we actually need these things? I agree with you that, ultimately, in terms of forcing corporations to do the right thing, that you end up with positive law. I mean, think securities regulation, think environmental regulation, all things that change the cost-benefit analysis. You also have, the essential nature of the firm. It seems like that the corporation ought to owe something for limited liability. I have a theory that I probably talked to you about because I won't shut up about a collaboration theory that's appeared in various places that suggests that. But what about market forces? Meaning that, if there really was a market to do good, and, if you talk to Alan Plummeter from Wake, for example, he claims capitalism is healing itself because people are now demanding the corporation do good things. Shouldn't we see corporations, for-profit entities, just gravitating towards that naturally without expecting business people who aren't necessarily trained in doing good, or want to focus on the bottom line because eventually when they get done with their PBC they want to go and work for a pure for-profit company? Shouldn't we expect that ultimately for-profit corporations will just turn this direction? So question one. Question two is in regard to thinking about the fiduciary duties and policing these entities, similar to Anat. I'm scared by them in the sense that we have this business judgment rule. Dodge v. Ford, as long as Ford had said, well, what I really want to do here is make sure that the Dodges never start a car company, he's okay. He got a smelter in that case because there was a business purpose there. All you have to do is articulate a business purpose. Wrigley, for example, with his lights for nighttime games, he just had to say he was worried about the property values in the neighborhood, and that was perfectly fine. It seems like what the duty to balance does is that it creates a circumstance where, essentially the managers of these companies can do whatever they want. My question is, have you seen anything regarding the duty of obedience, which you see in the nonprofit context, which requires nonprofits to actually adhere to what their promised public benefits are, starting to pop up at least in discussions? I know we don't have reported opinions here yet.
Okay, good, excellent questions. So I don't know if I can do justice to both, but I'm going to try. So the first question, in essence, I think, is do we need these? And the usual line of critique, Eric took a more sophisticated line, but I'll give you for those of you for whom that went by too fast. The usual line of critique is this. Under a doctrine called the business judgment rule, as long as directors are acting with information, like they reasonably inform themselves, they weren't grossly negligent in informing themselves, and they're acting in good faith, meaning it's a little complicated, but in essence, they're not purposely trying to hurt the company or violate the law or violate their authority, they're allowed to do more or less what they want, because judges are not experts in business, and they don't want to be the business decision maker of last resort for every corporation, and so they say, we're gonna review those decisions under a very deferential test. The last piece of the business judgment rule called either the rationality test or the weights test, depending on what kind of decision it is, which almost never fails. There are a few, but it almost never fails. So if that's true, why can't they just do what they actually have been doing for a long time, like give money to charity if they want to? They can. They have done it for forever. I mean, well, forever, since the 1880s. Why can't they pay their workers more if they want to? Why can't they do all of these things and just say, we're doing it because ultimately it will lead to better profits? And as long as they can say that with a straight face in front of a judge and a jury, they will win, right? So, and lots of critics have said this, including critics from the left who are worried about these things because they think, so like Lynn Stout, those of you who remember Lynn, Lynn would say, these are dangerous because they are teaching the wrong lesson. Corporations already are obligated to do this, which I think she was very much in the minority in saying that, although I respect her and love her dearly. She was very much in the minority in saying that. And by saying that there are these other entities, you're in essence saying, well, those entities are the ones who can do it, but the traditional corporations are not allowed to do it. And under the business judgment rule, they can, right? We talked about this, Lynn and I talked about this a lot. And I would say, yes, that's true as a practical matter, but certainly not as a cultural matter. And there's a difference between saying, I can get away with it, and saying, I'm actually obligated to do it. There's a really important, again, I'm all about culture. I think culture is a deeply, deeply underestimated force in business. And so how are we shaping that culture? If we're shaping that culture to, let's do something good and get away with it, that's very different, I think, than let's do something good because we've chosen a business form that obligates us to do it. So I can't believe I got through a whole lecture, I didn't say this because I always say it. I think PBCs are like having a workout partner. So if you the alarm goes off at 5:30 in the morning and for you to run to the gym and go work out, and there's no one waiting for you at the gym, odds are you're gonna hit snooze and maybe just go to work and not go to the gym. But if your friend is waiting for you at the gym, you're probably gonna get out of bed. Now your friend's not making you go to the gym, right? But you know your friend is waiting there. It's a good reinforcement tool. So I think this forum is like that. It's a very good reinforcement tool. It's not a good enforcement tool. So like Rick, I love Rick. Rick Alexander wants like Wells Fargo to force Wells Fargo to become a public benefit corporation. That will do nothing but weaken the form, right? I just don't think it will achieve anything. The business model and the culture have to be compatible with the legal form. In any war between culture, business model on the one side, and legal form on the other, legal form will lose all the time. Now for your second question, because I got too excited about the first one.
Duty of obedience.
So yeah, there's no duty of obedience in PBCs. There's nothing written to the statute about it. And if anything, if you wanted to enforce the duty, what there is a duty to balance. And if you wanted the duty to balance to really be enforceable, you would give the right to enforce it to beneficiaries and not just to shareholders. Or if you really care about that and you're one of the founders and you have control over the company, there are a lot of private ordering solutions that I invented and talk about in my book. So this is talk about nervousness. People are gonna be like, well, can you show me another company and they have documents for that? And I'll say, no, because I made it up. But it's a really good idea and I think it would work well. So the first ones are always the hardest. I had that trouble, by the way, with CEO Pay too. I had a public company. I went and lectured the board on how I thought CO Pay should be done, and the chair was like very gung-ho. And then I had a call from someone in the general counsel's office who's like, can you point us at language? And I said, I'll help you write it. They said, no, thank you. I never heard from them again. So
we're a couple minutes
over. Oh, we're over.
And I don't want to keep people late in case they have other obligations, but there is a reception upstairs, which I'm going to drag Michael to quickly so everybody can get his book, and we actually eat the food up there. But please come up and ask your questions there. Thanks so much for attending. This was an absolutely wonderful lecture. Thanks so much.
Thank you, Eric. Thank you guys so much. Thank you.
And reception's up in Lynn's place if you have questions.